Welcome to Clause 8, the voice of IP. Clause 8 is part of IP Watchdog and hosted by Eli Mauser. If you enjoy listening, please subscribe on your favorite podcasting app, share it with others, and leave a 5-star rating. This episode features an interview with Brad Watts, Majority Chief Counsel and Staff Director for the Senate Subcommittee on Intellectual Property. Under the leadership of Senator Thom Tillis, Brad led the herculean effort to fix the Section 101 patent eligibility mess. A series of Supreme Court decisions over the last decade have caused enormous confusion and uncertainty with regards to patent eligibility, and the Federal Circuit has proven unwilling and or unable to sort out this mess. However, members of Congress who previously led on patent issues remain fixated on the patent troll narrative. To the relief of many in the innovation community, Senators Thom Tillis and Chris Coons decided to lead in a different direction after the 2018 midterm elections. In the beginning, Senator Tillis said that they requested to reinstate the Senate Judiciary Subcommittee on IP because they saw a need to reform our nation's complicated patent process, starting with Section 101. Senator Coons noted that the patent eligibility mess discourages innovation in some of the most critical areas of technology, including artificial intelligence, medical diagnostics, and personalized medicine. The process for reforming 101 included multiple roundtables and extensive discussions with stakeholders, a framework released in April 2019, a bipartisan bicameral draft bill released in May 2019, and an unprecedented 3 days of hearings with 45 witnesses representing almost every imaginable view on the subject. At the end of those hearings, Senator Tillis said, "I want to do this quickly. I think we can review the record and make changes, garner consensus, and introduce a final bill sometime after the July 4 recess." That never happened. In an IP Watchdog interview earlier this year, Senator Tillis explained that the Section 101 reform process stalled because stakeholders refused to compromise. In another interview, he similarly noted that the biggest missed opportunity was enacting comprehensive Section 101 reform last year. We had a chance to achieve substantial reforms, but it stalled out because there was a lack of consensus amongst those who supported reform. A recent en banc Federal Circuit decision served as a stark reminder. Judge Kara Stoll, in her dissent, wrote, "One can still reasonably ponder whether foundational inventions like the telegraph, telephone, light bulb, and airplane would have been ineligible for patenting under the majority's revised approach." In short, Section 101 reform remains necessary. In this episode, Eli and Brad talk what really happened during this last attempt at reform, why it wasn't successful, where to go from here, and much more.
So first of all, thank you so much for doing this. And I want to start a little bit to get to know about you, Brad. When did you personally first become aware of patents? Do you remember? And what did you think about the roles that they played in society?
Yeah, thank you for that question. I mean, I think like all first-year law students, when you do your survey property course, right, you learn about the basics of intellectual property, and that was really my first exposure. I loved property in law school. It's just something that resonated and clicked with me, although I did not like, all the different commitments that run with the land. That was my least favorite aspect. But intellectual property as a property right is something that resonated with me early on. I graduated law school in May 2015 and was very fortunate to be able to come right up to DC and start working for then Senator Sessions on his Judiciary Committee staff. I like to tell people I did all of the non-sexy issues. So intellectual property, civil law, torts, anything that basically you would never see in the news, which I actually appreciated because those issues are below the radar. They tend to be more bipartisan, particularly intellectual property. The kind of partisanship that's associated with other Judiciary Committee issues aren't really in that space. And so, I got to immediately work on those issues, was fascinated by them, loved them because they're really weedy and wonky, things you can really dive into. And the law is very intricate, right? So as a young lawyer, getting to dive into some of these complex topics was really, really fun. So that was kind of my first really introduction to intellectual property. I didn't take any intellectual property classes in law school. Unfortunately, I'm not a patent lawyer, but have gotten to now for the last 2 years work almost exclusively on these issues and have really loved it.
So that's interesting. So it seems like you worked on IP issues from almost the very beginning. Just for like an outsider's perspective, how does a staffer like you get up to speed on some of these issues? Obviously, Section 101, it's not clear anybody can figure that out, what's going on with that. some professors spend their whole career studying patent eligibility issues, but that's just an example. How does somebody like you who's working on all these different issues come up to speed on something like that?
It's a very good question. I've been very fortunate. I've gotten to work on a number of issues on Capitol Hill, crime, terrorism issues. I worked exclusively on immigration issues for almost 2 years. I will say the approach I took when Senator Tillis first became a subcommittee is I really dove into kind of the weedy and wonky law review articles and papers that were out there. I think I spent all of December 2019 over the kind of holiday period going through multiple law review articles, some of the published literature out there, getting up to speed on not only the basics of eligibility law, how it works, how it functions currently, but some of the current debates around eligibility that have been ongoing for many, many years. That kind of primed me academically to think about those issues. And I think any policy issue that you work on is much like any other issue as a lawyer. You kind of learn as you go, right? The more you get into a topic, the more you're writing a brief, for example, or litigating certain cases, the more you learn the feel, the groove, the contours of an issue. And so that was kind of how I approached eligibility and intellectual property issues generally. It may sound dumb, but I spent that December too. I actually got a horn book, an intellectual property horn book, and just, basically taught myself basic IP law because, again, while I had done these issues before, I didn't have the deep academic background I knew I was going to need to be competent. So a lot of self-educating. I think what you'll find is most good staffers, and we have a lot of good staffers on Capitol Hill, particularly in the Tillis office, but most good staffers do that self-education and get a working knowledge of an issue and become kind of wonky so that they can engage with a variety of stakeholders.
We'll obviously talk more about it, but as you found out with 101, there's very heated opinions on both sides, and especially in some of these academic papers. How do you pick which academic papers to read? Is there somebody you talk to? Did you try to contact any? How do you know who to trust, basically?
Yeah, that's a very good question. I know from my perspective, and Senator Tillis is very much like this as well, we're driven by empirical data, right? What do trends show? Anecdotal evidence is just that. It's anecdotal. But you have to look at raw numbers, facts, and figures. Numbers don't lie. So that's the first thing I look for. What is the research supporting assertions that are made? I'm kind of one of those nerds who actually look at footnotes and I go and look at references. And we'll spread out kind of case books and textbooks or articles in front of me to cross-reference things. And then like anything else, good intuition, right? Particularly in personal engagement, when someone has a winning argument. You probably know that as a litigator very well, right? Sometimes you just know when you have a winning argument that's right. But yeah, Senator Tillis is very data-driven. Given his background at Wayne Laboratories, given his background, at IBM. And so I think that is a very big, important way that he goes about approaching intellectual property issues. What does the data actually lay out? And, as you well know, the data seems to be pretty clear. David Taylor's done some great work in this area and I hope I'm not butchering this, I think he's out of SMU, showing kind of the analytical data as it relates to investment trends, as a result of the current eligibility jurisprudence.
Obviously, by the time and correct me if I'm wrong, by the time you started working on these issues, Senator Tillis already knew about the problem with Section 101. You said he's data-driven, but what specifically, I guess, got him interested in that subject? Obviously, there's thousands of issues that he could be working on. What about Section 101 that got it on his radar?
Yeah, so Adam can correct me if I'm wrong about this, but, I think if you look at Thom's record since he came to the Senate, he's been a strong champion of intellectual property rights. North Carolina is a very innovative and dynamic state. There are numerous companies of all sizes, but particularly larger companies that are intellectual property dependent, right? They produce dynamic products, and if they don't have strong IP protections, there's no market for them. We actually just did an interview recently with an intellectual property trade association, and we talked about how the average wage in North Carolina is about $35,000, but the average wage for intellectual property intensive companies in North Carolina is about $53,000. That's a significant amount of money for a middle class family, right? So I think since he's been in the Senate, has heard from these companies about the strong importance of intellectual property protections. And just over the few years leading up to him taking the chairmanship, I think he's heard from them across sectors, but particularly in biopharmaceuticals, biosimilars, medical diagnostics, precision medicine, kind of the cutting edge of healthcare in this country, about how the current eligibility jurisprudence just doesn't work for them. It disincentivizes innovation. It disincentivizes investing in new products, which you well know. And so I think he had heard that enough that when he knew he was going to get the subcommittee chairmanship, he decided this was going to be, at least for the first year, his top priority. He's very innovation driven. He understands that given his own background. And so what he has heard, what he has read has resonated with him. And he really is kind of the academic and intellectual driver of this in our office. I like to think I'm a hired gun. Hopefully he thinks I'm a good hired gun, but he is the brains of the operation.
Yeah. I guess my understanding was, he knew this was a problem that needed to be solved. And that's when he kind of, with Senator Coons, they worked together to get the subcommittee on IP started. Is my understanding of that timeline correct? And why did he think that was really the best path to form this specialized subcommittee instead of just working in some other avenue through
Right. So he started really engaging on this at an in-depth level in October 2019. So, several months before the subcommittee, and we started working very closely with Senator Coons' office. Jamie Simpson, who's now the majority chief counsel on the House IP subcommittee, was really a big driver of this at the staff level, and I have to give her credit for that. But part of the reason why Senator Tillis wanted to form the subcommittee wasn't just to focus on patent issues, although that was a top priority, but there are a number of issues in intellectual property right now that need addressing. In the copyright space, Copyright Office itself needs to be modernized. Substantive copyright law, Digital Millennium Copyright Act in particular, needs to be updated. So he had heard about a number of these issues, and candidly, with several members of Congress like Mr. Goodlatte, Mr. Hatch on the Senate side, who were retiring, who had been kind of the champions of intellectual property, there was an opening to do some substantive, in-depth work. And, again, he's kind of a wonk. He likes these issues. Many members don't engage on these issues just because they're so far below the national radar. So he saw this really as an opportunity to get a specialized, dedicated subcommittee that could put in the time and the legwork to address not just eligibility issues, but a whole host of IP issues that are out there. And, I think if you look at his record just the last 2 years, it is the most active subcommittee on Senate Judiciary. He holds on average one hearing a month, which, let me tell you, as a staffer, can sometimes be taxing, but I'm glad that he's very driven to do that. He makes use of his subcommittee because he understands, yes, these issues might not be on the news every night, but they're important, and they're especially important to North Carolina.
So I guess my understanding is that by forming that subcommittee, he could really try to bring those issues more to the forefront by holding hearings and so forth.
Exactly right. It gave him a bigger platform, and it gave him resources, a subcommittee staff, to do the deep dive into these issues that you well know you have to do. If you could wave a wand and fix patent eligibility, it would have been done already, but it's a very wonky issue. I can't tell you how many hours and days I spent just reading law review articles or treatises as we were going through that process. So for him, having that dedicated subcommittee that could put that time and that work into these wonky issues was critically important. And, I think anyone who works in the IP space, even if they don't agree with the senator's position on intellectual property, would tell you he has put the time into work in this. He is a hard worker, and he has shown that he's serious. Even if you don't like the outcome he reaches, he's serious about these issues and learning.
I guess, obviously he formed the subcommittee, but did you have a plan in mind? Because you couldn't wave that magic wand to get that Section 101 passage plan, but did you have a model in mind how this would go about from the very beginning? Or did you know from the beginning that it's going to be maybe a really long process, and let's just start holding hearings?
I think there's a couple of questions in there. I'll start with kind of how Thom laid out the process he wanted, and then where he sees this over, the long term, 2 years, 5 years, et cetera. So when he became subcommittee chairman, he sat me down and he was very clear. He wanted a very methodical, thoughtful process on patent eligibility. And Senator Coons, I think, with his staff, was very much in a similar posture. And our companions in the House, Mr. Johnson, Mr. Stivers, Mr. Collins, we wanted to have a process that was thoughtful, that was engaging, and that was serious. As you well know, many members, they just drop a bill. They don't do a lot of legwork up front. They just say, well, I've heard about this issue, I'm going to drop a bill. Thom didn't want to take that approach. So we spent 6 months, both at the member level and staff level, having meetings with stakeholders, having roundtables, going through a process that refined the issue from kind of a high level, okay, this is a problem, what do you think, to specific. We solicited input from about 60 stakeholders, asking for specific statutory language, asking for specific as opposed to anecdotal evidence that this was a problem in certain areas. We produced several thousand pages of responses from roughly 60 stakeholders. Again, several thousand pages of legwork. The senator was very adamant, Thom was very adamant that we shouldn't just drop a bill without public engagement. We should actually release a draft, and we should do so publicly so that outside of the stakeholders we already worked with, anyone would have a chance to weigh in and have their voice heard. We did something very rare. Most bills get a hearing post-introduction. We held 3 hearings pre-introduction because, again, we wanted that public engagement. We wanted that public response. We wanted all relevant parties to feel like they had a chance to weigh in so that we could have all the evidence, all the data, all the comments, and chart a path forward. So I just really commend the senator because he wanted a thoughtful, methodical process. And regardless of, in my opinion, whether people agree with his positions on eligibility, I don't think anyone can criticize the process he put together. Not only the roundtable process, but the 3 hearings, 45 witnesses, thousands of pages of documents.
And how did he decide who should be involved in that process? What stakeholders? Because obviously, I'm sure it was apparent to you, even in a cursory review of where different groups stand, these radical leftist organizations like the EFF and ACLU, they're probably going to oppose any efforts to strengthen patent rights. Some of the groups that represent the big tech companies were pretty open about that as well. How did you think about, obviously you want to figure out where they stand, but how did you think about them contributing instead of slowing you down?
The senator wanted an open and inclusive process. And his mantra was basically anyone who wanted to engage in good faith, and that's the key term, good faith, was invited to do so. Now, as part of participating in the roundtable process, you had to submit answers to many detailed questions, provide specific proposals, and some people chose not to do that. They just said it wasn't worth it to them, and that's fine too. But the general posture was anyone who wanted to work in good faith could be part of this process. And then, of course, once we released the draft framework, we had 45 witnesses spread over 3 days, which is just unheard of on Capitol Hill because, again, the senator wanted to make sure that all kind of relevant buckets of viewpoints were heard. So we heard from law professors on all sides of the issue. We heard from companies on all sides of the issue. We heard from trade associations. We heard from EFF. We heard from the ACLU. Kind of all the relevant voices got a chance to weigh in. And that was important to the senator because he's a doer. He's someone who wants to get outcomes. And to do that, you have to take into account all legitimate equities. The question is, do you want to pass a bill or pass a law? And the senator very much wants to pass a law in this area, but that's going to require compromise in addressing all legitimate equities.
So I guess going back to my question before, in the beginning, did Senator Tillis think that it was realistic to get a law passed this Congress? Or did he more think about it, well, let's start this process because if we don't start it, then obviously...
Any major law, whether it's intellectual property or otherwise, but especially intellectual property, is a multi-Congress effort. Yeah, I think he knew that up front. The goal was to get a bill, ideally get it marked up, and set a marker for future Congresses for a second term. I think that's how stakeholders have to view this. This is a multi-Congress effort that's going to require compromise and addressing all the legitimate equities that are out there. And there are legitimate equities on kind of the anti-patent eligibility side. The senator doesn't agree that we shouldn't do anything. He absolutely thinks we should, but that doesn't mean that people who like the current state of play don't have legitimate equities that should be considered.
Right. His concern wasn't that these groups that oppose efforts to strengthen patent rights through reforming patent eligibility, he wasn't concerned that they would slow down the process because he thought actually giving them a chance to air out what they think in the long term, in the realistic term of getting this bill passed would actually help it. If it's a multi-Congress process, let them
I think it's credible to say there are some organizations who, their fundamental position is they think the current patent eligibility works and they would never support a reform. Yeah. That said, it doesn't mean that those organizations don't also have legitimate points on other areas. So, for example, we heard from several scientific research organizations that they were concerned that one of the implications of our proposal would be that you could patent human genes. That was never our intent, and we had been clear about that, but some people read our proposed statutory language as doing that. So the senator was very clear, hey, this is a legitimate concern we've heard. This was not our intent. We can make that clear. We can provide very clear language that says you cannot patent the human gene as it exists in the body. And he committed to doing that. And so that's, I think, how he envisioned this process is even if people ultimately disagree with his outcome, that doesn't mean that they might not raise things throughout the process should legitimately be considered. Several organizations raised the issue of a scientific research exemption. Okay, if you're going to broaden eligibility, can we consider putting in place, similar with what almost every other country has, a scientific research exemption? Very legitimate point that everyone, even the pro-eligibility stakeholders, agreed with. So, again, his thought was throughout the process, both the stakeholder roundtable process, the hearings, the goal was to ensure that all those legitimate viewpoints, who, again, they may never support a bill, but who have legitimate points, their voice was heard so that their equities could be addressed.
But do you think that concern about genes being patented, was that a good faith concern, or was that a PR move to kind of slow down the process?
The senator had indicated at the hearings, and you can go back and look, and I won't speak for him, but I think there were absolutely some organizations who perhaps used that as a straw man to just cause trouble. I also think there were some organizations who were legitimately concerned about that. And I think about a North Carolina resident, Dr. Karen Weck, who's at UNC Chapel Hill. She's a researcher who's done phenomenal research on, BRCA1 and 2 breast cancer genes. Her organizations were legitimately concerned that this could foreclose foundational and fundamental research in that area.
Yeah.
That's an easy fix because that wasn't what we intended anyway.
Right,
but hearing that viewpoint, hearing that legitimate organizations were concerned about that was critical, because if we just moved forward without addressing that could have caused a lot of trouble down the road, because we absolutely wouldn't want a court to say, under this new jurisprudence, you can patent a human gene as it exists in the body simply by discovering it. So that, I think, is a critical example of the type of good faith equities we wanted to hear and wanted to address.
And I want to dive into some of the specifics about, I guess, some of the drafts that were put out. But you said that you were actually asking stakeholders to come up with the language for the draft bill. How did that first draft bill that was released, that one-page draft bill, how was that put together? Can you give us insight? Do you want to give credit to anybody who kind of came up with that?
Well, to be clear, I know there were rumors circulating in the kind of the comments sections of certain publications, online, that somehow some shady tech companies had written this bill for us, or that some biopharma companies had written this bill. And that's just absolutely false. We solicited input as staff, and I want to go ahead and just practically give credit to other staff, Senator Coombs' staff, Mr. Nadler, Mr. Johnson, Mr. Collins, Mr. Stivers. Great staff. We worked together at the behest of our bosses. We as staff came up with that proposal. Okay. Now, of course, we had a lot of ideas to work off of. Of course, we had a lot of data to work off of, but we considered all the legitimate viewpoints, all the legitimate equities, and came up with that proposal, which we felt represented a consensus and a compromise that addressed the different equities. So no one wrote it. There was no pre-stocked language that we took. And this was very much a staff effort. And I want to give credit. It was Mr. Johnson, Mr. Stivers, Mr. Collins, brilliant patent lawyers. And so they deserve a lot of credit, as do the offices they work for.
Among those staffers who were working on this, was it difficult to reach a consensus about that first draft bill? Or were you all, by the time you kind of sat down to do that, it kind of was self-evident about if there is going to be a bill, it has to take this kind of form where you strengthen 112?
Good question. Was it difficult? Yes, but it wasn't because staffers were being difficult. It wasn't because our principals were being difficult. It was difficult because the subject is incredibly complex. I mean, as you know, some specialized trade associations or law groups have spent years trying to solve this issue. So, yes, it was a difficult process, but every single staffer in that room worked in good faith. I mean, there was one day we literally had dictionaries on the table, law review articles, Black's Law Dictionary, trying to figure out how to define certain terms, how to give certainty to certain terms. So it was a slug of a process. Again, hours and hours, thousands of pages of documents that we reviewed and helped form our opinions. So it was a slog, but everyone worked in good faith. Again, Tom, Jamie, Phil, huge academic legal minds that were really the brains of this operation and deserve so much credit. But when we released that draft product, again, I don't speak for those offices or for my colleagues, but I think everyone would say it was the product of many hours of hard work, thoughtful work, and we all legitimately believe this represented a true compromise and consensus that addressed what we knew were the legitimate equities at the time.
Yeah. And just from people who haven't worked in Congress, it's just a curiosity. When you staffers work together on the draft language bill, how does it work on a practical level? Do you go back and check with your
Right.
bosses about?
Ultimately, it's the principal's decision, right? I mean, the draft bill that was released was Thom Tillis's draft bill along with his colleagues, right? They are the principals. They hold the election certificates. They make the decisions. So what would happen is we worked through that process. I would go back and brief the senator, get his input, what he liked, what he didn't like, did he agree or disagree. My role as a staffer is to advise, to guide, and to warn. He is the principal, though, who makes the decision. And so, yes, I mean, absolutely, this was his product. This wasn't some draft written by staffers that we just threw out. I mean, this very much reflected his engagement in this process. For every hour of work I did, there were probably 2 hours of work on the back end, briefing the senator, discussing things with him, hearing his viewpoints, his own reading and conversations. Again, I'm an agent to effectuate what he thought was a very important issue.
Yeah, well, I guess just to think about it, it's a very significant time that Senator Tillis had to devote, and those other congressmen and senators.
Hours that these members devoted, not just to the behind-the-scenes work, but coming to stakeholder roundtables, just sitting through the hearings. I mean, I think the 3 hearings for 3 days alone were about 9 hours total. That's quite a significant amount of time for a senator to devote just to one really series of hearings. And he sat through all of them, heard every single witness.
And there were, some alternatives proposed that I thought had their own cleverness behind them. One was propose eliminate Section 101 altogether, make that the starting point, and then kind of go from there. Was that something that, I guess, Senator Tillis ever considered?
No, I mean, the senator was very clear that eligibility does play a gatekeeper role. Right. Now, the question, I think, is how broad or how narrow should that gate be? And should other functions of the Patent Act be more appropriately applied to settle some of these questions? And I think his position was the answer is yes. But I do think there's a threshold, gate, right? I mean, you shouldn't be able to patent, in theory, an idea. You shouldn't, in theory, be able to patent a natural observation. I mean, the question is, what are those things? And are there other aspects of the Patent Act that do have better clarity that could address that? So, for example, an idea, you couldn't patent an idea anyway, right? Because it's not embodied anywhere. There's no specifications. You can't meet many other requirements of the Patent Act. Yeah. 101 doesn't have to necessarily knock out ideas in and of themselves. That said, there's still an eligibility filter. So no, he never at any time thought that we shouldn't have an eligibility filter. The question was, has the exception swallowed the rule? And his opinion was, yes, they have.
Another argument some people made was, let's stop beating around the bush and saying what is useful, what is technical. Let's just, and I think you ended up doing it for genes, but let's make a list. These are the things that cannot be patentable. Was that something that you considered? Whether it be software, whether it be business methods, let's just make a list of things.
Reveal internal deliberations. The draft product we produced represented Senator Tillis's thinking and his colleagues' thinking.
Okay. Obviously, you mentioned the 3 days of hearings, the 45 witnesses. At least it seemed almost an unprecedented public way for all of these witnesses to contribute.
It was absolutely unprecedented, and Thom deserves a lot of credit for that. I mean, he was very serious that if we're going to do this, we're not going to have just a sham one-panel hearing and hear from a couple of pre-canned people who are going to affirm everything we want to do. We're going to have a legitimate, robust process that gives everyone, or at least every camp of people, because clearly you can't have every single person who wants to testify, just logistically, but every camp of viewpoints should have an opportunity to present their viewpoints. Some people think we didn't have enough witnesses. Some people think we had too many. Thom thinks we landed in the right place. And we had a broad, diverse set of viewpoints that had legitimate equities that were representing broadly the different camps.
And one thing that I think Senator Tillis pointed out himself is that representatives of some of the big tech companies were invited to testify, but they chose to not directly testify themselves. Do you know why that happened, or do you have any theories about why they didn't want to kind of?
No, I mean, I can't speak to any individual company's decision not to testify, right? I mean, I will say, to be fair to anyone who's a witness, it's a very not only daunting prospect, number one, but number two, it's a very time-intensive process, right? I mean, the many hours you have to spend preparing testimony, getting up to speed for who knows what kind of wonky question could be pulled out by some member. it's time intensive, right? And as you well know, many of these big tech companies have a lot of other issues they're dealing with right now. Section 230 issues, RDMCA issues, antitrust issues. And so I don't impugn any bad motives to anyone who didn't want it. Because again, that viewpoint was ultimately represented very well, by the way, by Dave Jones from HTIA. Dave and I don't agree on a lot of IP issues, but he's a great guy, a good friend, and very smart. And his testimony was very much valued at that process.
Yeah. And I've actually talked to Dave Jones about this as well. I guess my question is, from your perspective, did that signal to you that, well, even though Dave Jones said, we don't need this reform, at least it signaled to that those companies didn't really care that much either way, and you listed a bunch of other priorities that they might care more about?
No, I don't think that anyone should read in they don't care, and I'll just leave it at that. But Dave Jones's testimony was valuable because one of the things that came out of that was he indicated, that many of the high-tech companies would absolutely support a narrow kind of diagnostics only fix. Now, his proposal was to do it just as a sui generis fix, right? Some people disagree on whether that's the best way to do it. But my point is, even though HTIA and I'm assuming their member companies ultimately said, well, we wouldn't support a comprehensive 101 fix, there was an area for common ground saying, hey, we get it. We understand that it doesn't work for diagnostics, and we're not opposed to trying to help diagnostics. That's not a bad thing to come out of the process.
And there were some stakeholders, and I was going to ask you about that later, who were kind of concerned that there would be some kind of compromise that kind of got left them behind. There would be a narrow fix for, medical companies, medical device and pharma companies, while people who want to get software patents outside the medical field would be kind of left behind. I guess, what do you think about that kind of proposal?
I totally understand that concern, right? Everyone, I think, is legitimately worried that when a bill moves, it may be the last time a bill moves for a long time. That said, the question is, do you let the great get in the way of the good, right? And as Senator Tillis has noted in some of his subsequent interviews, the prospect of a comprehensive eligibility fix is highly unlikely, not only for what's left of this Congress, but probably for the foreseeable future. But the question is, it's like a surgeon, right? Do you let a patient bleed out because you can't do a big cardiothoracic surgery right now, or do you triage and stop the bleeding? And don't get me wrong, there are eligibility issues in all industries right now. The Chamberlain case is a great example, as Senator Tillis noted, I think, in a hearing last October. But again, triaging, I think it is most dire in precision medicine, diagnostics, biosimilars, et cetera. So do we let those industries die because we can't come up with a comprehensive fix now? Or do we try to triage this and do what we can when we can? And, again, Thom being outcome oriented, I think his view would be, look, if we can't get a comprehensive fix, let's at least stop the bleeding in the areas that are suffering the most.
That's interesting. Going back to those 3 days of hearings, 45 witnesses, at the end of those third day of hearings, Senator Tillis said, I want to do this quickly. I think we can review the record and make changes, garner consensus, and introduce a final bill sometime after the July 4th recess. And something obviously happened, that a bill wasn't publicly introduced within that time frame. Can you tell us what did happen and why did you have change?
Yeah, all I'll say is I'd go back to Thom's public comments where he said there's not stakeholder consensus. He's been very clear. He's not going to just introduce a bill as a talking point. If he wanted to do that, he wouldn't have spent the countless hours he spent learning this issue, talking with stakeholders. He himself read most of those documents that got submitted during the roundtable process. He was there for all 9 hours of the hearing. If he wanted to just introduce a bill that's a talking point, but that would never go anywhere, he would have done that in December 2018 and washed his hands. He wanted to produce a bill, though, that could actually have political viability and become law. That requires compromise. That requires consensus. A perfect approach is never going to become law. And I think we quickly realized some stakeholders want a perfect approach. That is their prerogative. That is their right. There's nothing wrong with that. But that doesn't mean that a politically viable path is there. And his position is, unless there's consensus among stakeholders on a politically viable path forward, there's not a prospect of a comprehensive bill.
We started this discussion, but I think you would agree there are some stakeholders who don't want to see any changes. There are obviously some stakeholders who are not going to agree to changes except if it's exactly what they want. So if there was a consensus, I guess, among who would this consensus have to take place? How would Senator Tillis know that there's sufficient consensus? How would that manifest itself?
I'm not going to call out specific stakeholders. I mean, all I'll say is, again, people have to ask themselves, do you want to let the great get in the way of the good? And the good requires compromise and consensus and acknowledging their legitimate equities. There are some people, for example, who would say, oh, well, there's no legitimacy that 101 plays a role in deterring abusive litigation. There's absolutely legitimacy there. Now, you may think that other aspects of the Patent Act should handle abusive litigation. That's a perfectly valid academic argument. But simply denying that 101 does play a useful role in invalidating patents that should have never been issued just ignores reality. I mean, the question is, how do you address that equity, litigation abuse at an early stage to knock out a patent that should not have been issued based on many other sets of criteria outside of 101? And I guess that's what I mean by not letting the great get in the way of the good. Not acknowledging other legitimate equities and realities is not a way to find compromise. And, the senator was very clear. We have to acknowledge and try to address those legitimate viewpoints.
Without naming any specific stakeholders, I guess, if you're one of these stakeholders or, you're one of these IP groups, IPO or that represents,
IPO is fabulous to work with. Sam Aguayo is great.
Right.
I'll be very clear about that.
No. I'm a member, so I'm not saying anything about that. I'm saying if you're part of one of these groups or you're part of a stakeholder from outside and you're trying to say, Senator Tillis is saying we need to form some kind of consensus. And you're trying to understand, well, who exactly does the consensus need to be between, or what can I do to kind of make sure that there's consensus? Because,
Well, I think the fundamental questions to ask yourself are, okay, again, do I want to fix the problem and get something done? And if the answer is yes, it's kind of like a diagram, right? If the answer is yes, you then have to accept that the purest approach, the most maximalist approach isn't going to be possible, because clearly what you think is the best outcome, nothing wrong with that, but it probably isn't what another group thinks is the best outcome.
Yeah.
So the question to ask is, do I want to get something done? Okay, I have to understand that I'm going to have to eat some things I don't want to eat in order to get it done. I think that's just what everyone needs to have their conversations with, whether it's a trade association, their bar groups, et cetera, is how bad do you want to get it done and what are you willing to accept to get it done? And those are conversations the other side has to have too. Like, okay, group A that opposes what Thom is trying to do, I get that he's going to do this anyway. What are my legitimate equities that I think should be addressed? Because clearly just saying, no, we don't want anything done isn't going to cut it. And he's said that multiple times. But what are the legitimate things that we think need to be addressed? So that would be my advice to everyone, is if you want to see something done, make that known in whatever group you're a part of, that, hey, I don't want you to keep letting the great get in the way of the good. This is an important enough issue for me that I think we should be willing to swallow some things. Now, there's probably disagreement on what different things people think they have to eat, but that's the starting point at least. And I think there is still some disagreement on whether anything less than a maximalist approach should even be a starting point.
Yeah. So I guess I want to try to ask this one other way. So I guess the issue was, and maybe my misunderstanding is that there was just so little consensus. There was so little consensus that there really wasn't a way to move it forward.
Well, I think it depends. I think there were consensus about some things. So, for example, everyone was supportive of a scientific research exemption. That is just putting us on the same playing field as almost everywhere else in the world, right? Everyone was supportive of making clear that you can't patent human genes in the body. So there was high levels of consensus on some pieces. Section 112, really no consensus there, right?
Yeah.
So, I think it's important to understand, there's consensus in some places, but not consensus in others. And it's probably the places you don't like or hate that there's going to have to be consensus. And 112 is actually a really good example of that.
For maybe a future Congress where this is taken up again, is a lesson then don't nitpick every single part of the proposal because that's going to slow down the process, or is that not the right takeaway?
Thom uses this analogy quite often, and Adam can correct me if I'm butchering it, but he likes to think of things as green, yellows, and reds. Greens are things you absolutely want. Yellows are things you're kind of iffy on. You don't love it, but you don't hate it. And reds are things that are red lines. You won't accept it. I think that's how stakeholders, not just in intellectual property, but any context, have to think about any bill. Greens, reds, and yellows. What are the parts you love? What are the parts you hate that have to be done away with or you want to see gone? And what are the yellows? And the question becomes, do the greens sufficiently enough outweigh the yellows and a handful of reds to make it doable? Because you're never going to get 100% green. Hopefully you never get 100% red, but is it on balance enough green to make it worth doing? But people have to accept they're never going to get a bill that's 100% green. And if they do, it's probably never going to become law.
And I want to ask, I guess, one last question about the process. You introduced publicly that one-page draft bill. You had those 3 days of hearings, public hearings. At a certain point, it was reported that there was a 3-page draft bill that you had to come to Congress to look at secretly, and you couldn't talk anything about.
Richard Lloyd is a fabulous journalist, also a friend. I'm consistently impressed by his reporting, and that's all I'll say.
Okay. If you want to share anything, are there any lessons about why you changed strategies in terms of making it super open?
I will just say Richard is a fabulous journalist who always does a wonderful job in the stories he writes.
All right. Before we end this conversation, obviously, unless a miracle happens, probably there won't be a Section 101 law passed. But at what point did you realize, I guess, was there a point in time where Senator Tillis made him think, it's not going to happen this time around in Congress?
I think it became apparent after the hearings there was a lack of stakeholder consensus on some of the elements that were going to be needed to get a bill that was politically viable. That said, he hasn't stopped working on this issue. It's still something I'm working on. He has indicated in some of his recent interviews with APLA, for example, that he is exploring actively right now a narrow fix that can help, kind of stem the bleeding in the diagnostics precision medicine space. I'm spending a good bit of time over August recess looking at that. He and I are having conversations. He's doing some reading. He's talking to people. So the issue hasn't gone away. It hasn't died. I do think, at least as of now, the prospect of a comprehensive bill is not possible until there's stakeholder consensus. And, the senator is deeply engaged in a review of the Digital Millennium Copyright Act. He's been holding hearings all year on different aspects of the DMCA. And, he's hoping to produce a DMCA reform draft for public comment and review by December. And that's going to be a top priority as well in the second term. And I would say those are his 2 top IP priorities based on my conversations with him for his next term. It's finding a path forward on patent eligibility and reforming the Digital Millennium Copyright Act. He's very passionate about both.
There was a recent Federal Circuit decision, the American Axle decision on Bank, where all the Federal Circuit judges seemed bitterly divided about what Section 101 means. Does that impact the thinking about the urgency of resolving this matter? Or really, as long as, like you said, if there's no reasonable consensus, it's not going to really...
I think it's urgent. It was urgent last year. It's going to remain urgent. It's probably been urgent for several years before Thom took up the mantle of this issue. But, again, as a threshold level, there's got to be a willingness among stakeholders to accept compromises that they may not love. Number one. And number two, there's got to be an understanding that this is going to be a multi-year, multi-Congress process. And that's just the nature of the legislative beast, which is ultimately, in my opinion, a good thing because it produces bills that represent a high level of consensus, which are better for society in the long run.
Moving, I guess, a little slightly from 101, you mentioned that it's a legitimate use of 101 that some groups want to have.
It's a legitimate business tactic and litigation tactic. Whether Thom ultimately agrees that it's appropriate is different. It doesn't mean it's illegitimate.
Yeah. So, it's funny because if you talk to patent attorneys from these big tech companies off the record, a lot of them will tell you, from a coherent legal standpoint.
I had several tell me that, I could take out a patent under 112 or obviousness or novelty, but that's going to take me a lot longer. It's going to be at least a marksman hearing, if not getting to summary judgment. And that's a lot of money for my company. That's $1 year and $1 million as opposed to a 12B6 motion. Would we really do any different if it was our client? No. Ethically, we have to do what's best for our clients.
Yeah. And 101 is really a package of tools that defendants now have, along with the PTAB, to kind of deal with patent litigation. And really, at the end of the day, it's really about who has more leverage. How does Senator Tillis, does he have any thoughts about, I guess, the PTAB? How's that working out?
Thom has been very clear. There's a role for the PTAB, right? There is a role for kind of these AIA proceedings. The question is, are these roles appropriately limited in scope? Are they fair? Are they equitable? He's been very clear that he does think there were procedures at PTAB that were unfair to patent owners. That's why he sent a letter to Director Iancu on many of these things. He has supported Director Iancu incorporating the Phillips standard. He supports the valve and general plastic factors. And he would support codifying many of the actions Director Iancu has taken in the presidential opinion panel, to ensure there are fundamental aspects of fairness for litigants at the PTAB. Serial petitions, he's been very clear that he thinks there's abuse in the serial petition process. That said, he's also been very clear that you shouldn't just get one bite at the apple at the PTAB. There are some legitimate reasons for filing multiple petitions, but you shouldn't do it just to bankrupt a company because you don't like their intellectual property. So he doesn't want the PTAB to go away. He doesn't want to dismantle it, but he does think there are some things that should be codified to appropriately constrain it so it is a fair forum. Congress never intended it to be a forum that would be a death squad for patents, but there is a legitimate role for it to play.
We discussed, sometimes defendants want to get rid of patent litigation cases really quickly. But on the flip side, there's a strategy of defendants stretching out cases forever until, whoever's filing a lawsuit loses the ability to pursue their cases.
That's, as you know, it's not unique to patent law, right? It's an issue in the litigation system generally. Sometimes you don't have to win. You just have to get the other person to give up.
Yep. So I guess any concern or thoughts about whether that needs to be fixed, or that's just part of, the legal system and you can't really...
I think at a high level, right, and this is me speaking personally and not for Senator Tillis, I think at a high level, no one would say the justice system, whether it's in IP or any other context, should be so prohibitively expensive that you have to give up on asserting your rights or defending your rights because you can't afford it. And again, that's not unique to IP. How do you fix that is a much bigger issue than what can be addressed in the IP context, right? So I'm not trying to be evasive as much as just saying it's a legitimate issue. I don't know, in my opinion, how to fix that because it is so beyond just an IP-specific issue.
Right. I think that's a clear answer. It's hard to fix. So.
Oh, good.
I wanted to, since we have a chance to talk with you, to get some advice for people, who might think there's some problems with the IP system, but don't know where to start about communicating these things to members of Congress and so forth. Let's say somebody wants to get in touch with you or Senator Tillis to tell them about these issues. What's the most effective approach? Should they call your office, join some group?
Thom is really good about promoting an open and transparent office, and particularly on our IP subcommittee. He has kind of told me multiple times, at least an initial meeting, anyone who wants to get one or talk, you should do it. Now, I say at least an initial meeting for a reason, right? Some people kind of want to dominate time, and I don't have time to really meet with people 8 or 9 times to talk about the same things. But that doesn't mean, at least for a couple of meetings, you may not have legitimate points and views you want to raise. And I try very hard to meet with almost everyone who reaches out, or have someone on my team meet with people who reach out, so that they can have their opportunity to be heard. I will say people on the outside have to realize just because we are giving you an opportunity to be heard doesn't mean that ultimately the senator is going to take the position you want him to. And it doesn't make him or us as staffers bad people. And I do think sometimes people conflate that. They think the opportunity to be heard equates to you must do what I want you to do. And those are very different things, because for every one stakeholder we hear from who wants X, we probably hear from a stakeholder who wants Y. That is why you usually have to forge consensus, because usually one individual's viewpoint is not the only viewpoint.
Putting it outside the one-on-one context. Let's say some very esoteric problem that you need fixed for whatever reason. How do you elevate it to the point? You seem extremely accessible and extremely open, but how do you get it elevated to a point where the senator thinks, well, this is important enough, like you said, to devote so much time and effort to this?
Thom, ultimately he makes the decisions, right? He is the senator. He is elected and accountable to the people, and he's smart as a whip and he knows what he's doing. But he is also really good in our entire office. Thom is great about having open access. Everyone from the staff assistant, who is the most entry level, usually staffer in an office, to the chief of staff can pretty much walk in and talk to him at any point. Now granted, if he's in a meeting, you can't kick the door open, right, and interrupt his meeting. But he's in the office regularly, and he regularly just has his door open, and anyone can walk in and talk to him. You can talk to him about life problems. You can talk to him about work. You can talk to him about anything. And so if there's an issue, and it's not just physically. I mean, you can email him as well. Anyone in the office can email him. So if there's an issue I think that is of importance that he needs to spend time on that is not already on his radar because of his own work and involvement, I'll just email him or I'll text him or I'll walk in and say, hey, sir, have you heard about this? Sometimes he has, sometimes he hasn't, and we'll talk about it and he'll make the decision. It's important for people to realize, too, just because he's not working on an issue right now doesn't mean he's not going to dedicate time to it later. There's only so much bandwidth for so many issues. And he is very adamant that when he engages on an issue, he wants to do work. He's personally involved. He's reading the materials. He is in the thick of it with the staff. So he wants to make sure when he takes up an issue, he wants to have the time to put that amount of work into it. So that's what I would say to people too. Understand, just because we can't take up an issue now doesn't mean it's not important. It doesn't mean we won't take it up at some point. And that's why people should reach out, because you may flag an issue for me that I haven't heard of that is critical, that fits with the objectives Senator Tillis is trying to achieve. And that's an opportunity for me to get that in front of him and get his opinion on it.
That's great to know. Another question that I have is that, let's say you're from a different state and you want your congressman or senator to support what Senator Tillis and Coons are doing. What would you suggest, aside from talking to their, and I'm talking specifically, let's say for 101, what would your recommendation be? Is this the right time even to talk to them about this, or let's wait?
I always encourage people to reach out to their members, right? I mean, the right to petition is enshrined in the First Amendment for a reason. Reaching out, talking to your members and their staff is, the right to petition. But people need to understand, right? Congressional staff usually have a million different issues they're dealing with at any given time. Even though I do primarily IP issues, the senator is still on the Judiciary Committee as a whole. And so I have to help him with a number of issues. Now I have a team to help me, but at any given time, I may be juggling 8 or 9 different things on top of the very intensive work I do on patents. And so people have to realize when you reach out to congressional staff, they may not know anything about intellectual property because they may be handling 12 other issues. And they especially may not know about all the weeds and the cases and the intricacies of eligibility. Be patient, teach, educate, have a story. Not only tell them the law, but tell them why this is important to you, to their district, to a company. Don't go in and assume that if they don't know anything, that they're hostile to you. Use it as a chance to educate. I've learned a ton from constituents that things I'd never thought about, perspectives I've never thought about, through those conversations. That's a good thing, and you should view that as an opportunity.
I guess my last question, let's say you do have a chance, let's say you're at a fundraiser or something and for a senator and you get a chance to talk with him and he finds out you're interested in patents, and then you tell him you think Section 101 is a big issue, and he goes, what is that? What is the story that I guess stood out to you?
First off, I would say you should never approach a senator with a policy ask at a fundraiser. And Thom is actually really, really good about that. Of course, everyone talks generally about policy, but he doesn't conflate the campaigning side with his official capacities. He's very good about keeping that firewall. And despite some of the rumors that have circulated on the online chatter boards, he has never once come to me and said, we have to do X because someone put a fundraiser for him. He would never do that. He's a person of the highest integrity. So I would never approach anyone at a fundraiser. But, say you're at a town hall, or say you're at an event where the senator is there in his official capacity. Realize that Senator Tillis is very engaged in IP, so is Senator Coons, but there's only a handful of members who are really engaged on these issues. And again, it's not because it's not important, but they may have issues in their state that are higher priority. So realize the person you're talking to may not have the level of background and depth of expertise as not only some other senators, but especially you. So you should have a 30-second elevator pitch to explain, not only in understandable terms, but in relatable terms, what this issue is and why it's important. So a 30-second elevator pitch about, here's the issue, here's the problem, here's why it's important to your state. Engage their interest. And that's when, if they engage with you, you go into some of these more in-depth conversations.
That's great advice. Thank you so much for doing this, Brad.
No, not a problem. Thank you.